Very often, people will try to squeeze a contracting relationship into what really should be an employment relationship. Now, the terms of the agreement, that is, the agreement which says you will be a contractor, aren't completely irrelevant to the distinction. It is a relevant factor. But you can't turn someone who is in truth an employee into a contractor. And there can be significant problems if you try to do that and get it wrong. So people will say to me, well, what will it hurt if I call this worker who wants to be a contractor rather than an employee? And the answer is it can hurt in an awful lot of ways. I have one case on my desk at the moment which basically revolves around a working relationship that went on for 5 years. The parties treated it as a contracting relationship. Now I've got a claim in the federal court where this fellow is suing the former employer for something like $600,000 plus because he says over the whole of the 5 years in question he wasn't really a contractor, he was really an employee and he was entitled to all the things employees get and he didn't get. It's become a very difficult claim for the employer to manage and very expensive. Other problems can also arise in the tax space, in the workers' compensation space, and under the Fair Work Act, which prohibits what's called sham contracting. The other thing to think about is this. In an employment relationship, regardless of whether you've documented the employment contract properly or not, the law regards an employee as holding or having special duties of trust and confidence to their employer. It's an implied incident of employment. You don't have that in the contracting space. You have an independent business who, for all intents and purposes, is in business for themselves to look after their own interests. So if you've retained someone in a mission-critical role as a contractor rather than as an employee, you've actually deprived yourself of some valuable rights that as an employer you might really want to have. When it comes to documenting an independent contracting or consultancy arrangement, again, that's a process that's not really straightforward, even if the details or the basics of the arrangement are quite simple. Bear in mind that in an independent contracting arrangement, there is no control, there are no implied duties of trust and confidence, and so on. So as the principal or employer in that arrangement, you need to be very careful up front to document precisely what you want out of it and how you want it to unroll. You can't assume that you'll have some influence like an employer would have to go on and control things that happen during the course of that relationship.